And when Obamacare passed in March of 2010, we filed our suit within 3 days. That's how quickly we can move, because we're all in agreement on these issues. And I think we must have had an emergency board meeting or something, we authorized it, and we worked around the clock to get it done. So we filed our suit, the states filed their suit, and Virginia filed its suit. And these cases percolated through the system. Virginia's case was filed in Virginia. Unfortunately, that goes up to the Fourth Circuit. The Fourth Circuit has become one of the most liberal circuits in the country. And the way our court system in the United States is divided is there are, I guess, 13 circuits around the country, with each appellate court having its own jurisdiction. Out here in Nevada, this would go up to the Ninth Circuit, which is also very liberal. You've probably heard Rush Limbaugh talk about the Ninth Circuit. He refers to it as the Ninth Circus. But the Fourth Circuit's gotten very liberal too. So that case brought by Virginia, Ken Cuccinelli, I think you all heard about it a year or 2 years ago, it fizzled. It ended at the Fourth Circuit. The case that's before the Supreme Court was the case filed by what became 26 states, and that was filed with Judge Vincent in Pensacola, Florida, which is one of the most conservative areas of the country. Pensacola, Florida, that's in the Panhandle. There's a lot of military residents there, and it's just extremely conservative. And he struck down Obamacare as unconstitutional. It went from there up to the 11th Circuit, which presides over Florida, Georgia, and I think South Carolina. The 11th Circuit is not particularly conservative. And that was a surprise when the 11th Circuit ruled by a 2-to-1 margin. You get 3 judges on an appellate panel. And by a 2-to-1 margin, with one Democratic appointed judge crossing over and voting against Obamacare, they struck down the individual mandate. But they did not strike down all of Obamacare. They simply struck down the individual mandate, and the 2-to-1 panel said that the individual mandate is severable from the rest of the act. Now, severability is a legal concept whereby a court will look at a law and say, if there's some part of a law that's unconstitutional, can we take that part out and leave the rest of the law intact? If they do that, then they are severing the unconstitutional provision from the rest of the law and upholding the rest of the law, and that's what the 11th Circuit did. So they struck down the individual mandate as unconstitutional, but they kept the rest of Obamacare intact. Meanwhile, all the other appellate courts have upheld Obamacare. So the Fourth Circuit did, the Sixth Circuit did, and I believe some other courts have as well. So among all these affirmances, some of them by judges were appointed by Republicans. The D.C. Circuit, it was a Reagan-appointed judge who upheld Obamacare, who provided the votes, the second vote on the 3-judge panel to uphold Obamacare. So amid this sea of affirmances for Obamacare, only the 11th Circuit, by a 2-to-1 margin, the narrowest of margins, struck down Obamacare, and they only struck down a part of Obamacare. They didn't strike down all of it. They only struck down the individual mandate. Well, from there, the Obama administration had the opportunity to petition for rehearing en banc, which is what is ordinarily done when someone loses a big case before a 3-judge panel. Someone then asks, an attorney on the losing side will then petition for the entire circuit, which may be a dozen judges or so, it depends on which circuit it is, but all the active judges on that circuit, the losing side will typically ask for all the judges to rehear the case. And if it's a case of great significance, as this was, the expectation is that the Department of Justice would request for a rehearing en banc, which they might have won, because the 11th Circuit is not particularly conservative. They might have been able to win this case without ever going to the Supreme Court by getting a rehearing en banc. And if they had won that, then all the circuits would have been in agreement. They would have all held that Obamacare is unconstitutional, and we may have never gotten to the U.S. Supreme Court. Well, AAPS filed a brief in the 11th Circuit case. We were right there. We were the only the only major medical society to do so. There was another new doctors group that may have joined our brief. They may have filed another one, but at least among the major medical societies, we were the only one in the 11th Circuit case. We also filed a brief in the 4th Circuit case. The government has 45 days to petition for rehearing en banc in a case. As that clock was ticking, the expectation was the government would do this, but the time ran out and they never did it. And there's been a lot of speculation why the government, the Obama administration, never petitioned for rehearing en banc before the 11th Circuit to keep this from going up to the Supreme Court. And by the way, if they had done that, even if they had not gotten a rehearing en banc, they would have slowed the case down, and the Supreme Court would not be deciding it in an election year. So they could have at least slowed the case down and punted this issue until after the election, but they didn't do it. And nobody has a good explanation for that, but the only thing I can say, knowing Obama in law school, knowing what his work ethic is like, knowing how disinterested he really is in most of these issues, was he never gave the approval to file for that petition for rehearing en banc. He could never make that decision. He never got around to it. He was too indecisive, he wasn't focused on it, and the clock ran out on him. That's what I think happened, knowing him and his personality. This ObamaCare, it's named after him, but this has never been an issue of interest to him. He doesn't even understand the medical profession. You see that in his gaffes, right, when he talked about how much he thinks doctors charge for an amputation. He doesn't know what he's talking about. He's not interested. So the clock ran out. So at that point, they were done at the 11th Circuit level, and immediately the petitions to the U.S. Supreme Court started occurring. And AAPS filed another amicus brief. This is what an amicus brief looks like. This is what all briefs to the Supreme Court look like. They're in a small booklet form, so it's easier reading. Court can open it up. There's strict page limits. You're supposed to keep it on the short side, and they enforce those limits strictly. We were the only medical group to file one of these to urge the U.S. Supreme Court to take this case. The U.S. Supreme Court, not only did they take the case, but they took the case on a number of issues. And one issue they took it on, for example, is on the severability issue itself. They have a special argument and a special consideration of whether the act can be severed into different parts. And that is terrific news for us, that the Supreme Court is going to consider that issue separately, whether you can break this act into pieces. And our argument is, no, you can't break it into pieces. If any part of this act is defective, the whole thing is declared unconstitutional. That's our position. There is no severability provision in the law. Usually when a legislature wants a court to sever something, sever anything that's unconstitutional, they'll put a provision right in the law that says if any portion of this law is held unconstitutional, preserve the remainder. But that provision is not in Obamacare. There is no severability clause in it. And therefore our position is a court cannot go in and pick and choose. And just as Wayne explained, if you allow courts to go in and pick and choose, it's like a line item veto, which is also unconstitutional, where the president was once given the authority by Congress to go in and pick and choose which part of a law he wanted and which part he wanted to strike, and the court said, you can't do that. That's not the way our separation of powers works in this country. Congress passes a law, the president either signs the whole thing or vetoes the whole thing. You can't pick and choose. And similarly, the courts either have to uphold the whole thing or strike the whole thing down. They don't get to go in and rewrite the law by deciding what they like and what they don't like. That has already been briefed, that issue of severability. We're on a fast track here. We're going to get a decision on all these issues by the end of June. So we're talking less than 6 months from now. We're going to have a decision, or about 6 months from now. The severability issue has been briefed. Again, AAPS was in there with our amicus brief. We were the only medical group in there on this issue, and we argued that no, courts cannot pick and choose with this law. And by the way, imagine what a mess this is going to be if the Supreme Court were to pick and choose and uphold some parts and strike down other parts. If they were to strike down the individual mandate but uphold the rest of it, how does the thing get paid for? how's the thing function? The individual mandate was the funding for these new burdens on insurance companies. Insurance companies are not going to be able to cover everybody the way they have to now with all the pre-existing conditions if they don't have the benefit of the individual mandate. Well, if the court strikes down the individual mandate but upholds the requirement that insurance companies cover pre-existing conditions, insurance companies go bankrupt. You just get chaos in the way the current system works. And maybe that's not such a bad thing if the insurance companies went bankrupt, but regardless, it's not what Congress intended. So courts should not be doing something that's not what Congress intended. The second issue that's been briefed before the Supreme Court is a fascinating issue that does not get much airplay in the media. But that is how Obamacare requires states to expand their Medicaid coverage. And Obamacare forces states to make a decision. Either states must massively expand the number of people they cover under Medicaid, or states must pull out of the Medicaid program and not receive any federal money for Medicaid. That's the dilemma they're put in. And as we filed a separate brief on that issue. I passed it around earlier. States are put into the choice where either way state spending goes way up. If states take the choice they're going to expand their Medicaid coverage, then they have to increase their taxes and spending to pay for that. If they decide they're not going to increase their Medicaid coverage, then they lose all that federal money, which is billions of dollars. And then states are going to have to increase their taxes and spending to do that. So basically, Obamacare is bankrupting the states with this Medicaid requirement, and that's unconstitutional. You don't hear this discussed a lot, but actually I think this is our strongest argument, the U.S. Supreme Court, because the justices, while they may give deference to Congress, and there is some concern about how Justice Kennedy may feel about some of these issues and so on, they're not going to completely destroy the states. There are 5 votes there that believe in preserving the existence of the states. And there are 5 votes for respecting the federalism that we have in this country, so that states are independent, meaningful entities that cannot be told by the federal government that they have to raise taxes to cover more people under Medicaid, or that they're going to lose money if they don't do that decision. So I'm confident, and we won't know until the end of June, but that there are 5 votes for striking down that Medicaid expansion provision. And many people were shocked that the Supreme Court granted cert to consider that issue. But that was a sign that they're upset with the way Obamacare obliterates state government, basically. If we win on that issue, and then we win on the severability issue, and it looks good we'll win on that, then that's it. Obamacare disappears, regardless of whether we win on the individual mandate. So that's the beauty of the way this is shaping up. And of course, it's become such a big case now that I think it's really up there now on the same level that Bush v. Gore was back in 2000, if you remember that case. Bush v. Gore, that case got to be so big that really, it's like in the financial world where you get the expression too big to fail. It's the same sort of concept. When a case gets that big, you don't get people straying from one side to the other. I think it's really unlikely that you're going to see Republican-appointed justices cross over to the Democratic side, just as they wouldn't do it in Bush v. Gore. I think that really the Obamacare case now is too big to get any surprises by the Supreme Court. I think you're going to see the 5 Republican-appointed justices vote to strike it down, the 4 Democratic-appointed justices to vote to affirm it, and as we saw the outcome in Bush v. Gore. So I'm fairly optimistic that by the end of June, the Supreme Court will be throwing out Obamacare, and we've got our briefs in there to argue for exactly that result.